Generally, under an assignment of rents clause in a mortgage or a deed of trust, the mortgagor transfers its interest in rents flowing from the mortgaged property to the mortgagee. But can a mortgagee protect its interest in rents simply by recording the document in the land records? In the case of In re Millette, the U.S. Court of Appeals for the Fifth Circuit considered this question. Thomas Millette, William Millette, Ted Millette, and Charles Fridge owned a commercial building in Jackson County, Mississippi. In 1992, the Millettes received a loan from Eastover Bank and executed a promissory note in Eastover's favor. As security for the note, the Millettes also executed a deed of trust in Eastover's favor. The deed contained an assignment of rents clause under which Eastover had the right to collect the rents from the building if the Millettes defaulted on the loan. The note and deed were recorded in the Jackson County land records. Later, an investment company purchased the note and deed and hired Security National to service the loan. In 1993, O'Neill Steel obtained a judgment against the Millettes in Alabama, and in 1994, O'Neill enrolled or recorded the judgment in Jackson County. The Millettes then rented the building to Jackson County. Shortly afterward, O'Neill discovered that the Millettes were receiving rents from the building and filed a garnishment action. Security National intervened and instituted a foreclosure action. Before Security National could foreclose, the Millettes filed for bankruptcy, which stayed the garnishment and foreclosure actions. In the bankruptcy case, O'Neill brought an advisory proceeding to determine the priority of the competing liens on the rents. Specifically, O'Neill argued it had a priority interest in the rents over Security National's lien, because Security National didn't take the additional steps to perfect its interest before O'Neill filed its garnishment action, such as appointing a receiver. Security National moved for summary judgment, which the bankruptcy court granted. In granting the motion, the court held that Security National had a perfected interest because the deed of trust was recorded on the land records. O'Neill appealed to the U.S. District Court for the Southern District of Mississippi, which affirmed. However, the district court held that Security National had to take additional steps to perfect its interest, but that its actions upon learning of the garnishment action sufficed. O'Neill appealed to the U.S. Court of Appeals for the Fifth Circuit.